Section 63, Secondary Evidence. In a case of Chimanji Govind Godbole versus Dinkar Dhondev Godbole, 1886, 11 Bombay 320, it was held that this section describes what constitutes a secondary evidence. Secondary evidence which may be given under certain circumstances in the absence of that better evidence which the law requires to be given first. Secondary evidence means and includes certified copies, copies made from the original by mechanical process, and copies compared with such copies. Copies made from or compared with the originals. Counterparts of documents as against the parties who did not execute them. Oral account of the content of the document by person who has seen this. K. Lingam versus B.V. Chandrasekhar Gowda, AIR 1993, Karnataka, page 29. It was held that the power of attorney registered with the sub-registrar has been held to be not a public document. A certified copy of such record is a secondary evidence. In a case of Kumari Viraiya versus State of AP, 1995, 4 Supreme Court cases, 136, it was held that certified copy of a sale deed were held to be admissible as secondary evidence. The court, however, said that they could not relied upon unless the vendor or the vendee was examined to prove the consideration for the transaction and other circumstances such as a nearness to a land. In the case of Government of AP versus Kari Chinna Venkata Reddy, AIR 1994, Supreme Court 595, it was held that copy of a copy, that is, copy transcribed form and compared with a copy, is inadmissible unless the copy with which it was compared was a copy made by some mechanical process which in itself ensures the accuracy of such copy. Is of a copy kept in registration office when signed and sealed by the registering officer are admissible for the purpose of proving the contents of the original. Later process copies and photographs of writings are secondary evidence. Photostatic copies of a document should be accepted in evidence only after examining the original copies. In a case of Northland Traders versus Bank of Baroda, AIR 1994, Allahabad 381, it was held that photostatic copy of the power of attorney executed by competent authority and authenticated by notary public and proved from original is admissible in evidence. In a case of J. Patel and Company versus National Federation of Industrial Cooperative Limited, AIR 1996, Calcutta 253, it was held that in absence of any evidence that the originals were delivered to the addressee, the copy of the letters carry little evidentiary value. In the case of Ratan Sharma versus Ambassador Dry Cleaners, AIR 1997, Rajasthan 75, it was held that the photostat copy of a rent note which was proved to be photostat of originals, though not compared with the originals, was held to be admissible. In a case of Bhavnagar Municipal Corporation versus Jadeja Chambua, 2014, 16 Supreme Court cases 130. It was held that while it is true that the Xerox copy of certificate may not be evidence by itself, especially when the respondent producing the same had stated that the original was with him, but had chosen not to produce the same, yet the document was allowed to be marked at the trial. Strict rule of evidence, it is fairly well settled, are not applicable to the proceedings before the labor court. That being so, it was held that the admission of the Xerox copy of the certificate without any objections from the opposite party could not be faulted at that belated stage. In a case of Santaram versus Ghasitaram, 1956, 9, Punjab 193, it was held that the copies made from the original or copies compared with the original are admissible as secondary evidence. A copy of a copy, when compared with the original, would be receivable as a secondary evidence of original. It lays down in an express language that a copy transcribed from a copy but afterward compared with the originals is secondary evidence. But a copy not so compared is not secondary evidence of originals, although the copy from which it was transcribed was compared with the originals. An entry in the deed of writers register which contain all the essential particulars contained in the document itself and is so sign or thumb mark by the person executing the document amounts to a copy and is admissible in evidence. In the case of Ram Prasad versus Raghunandan Prasad, it was held that a copy of a certified copy of a document which has not been compared with the original cannot be admitted in evidence, such copy being neither primary nor secondary evidence of the content of the original. In the case of Mahadeva Royal versus Veerbhasava Royal, 1948, 50 Bombay Law Reports, it was held that a copy of a document not compared with the original document was held to be not admissible in evidence. A decree based on such a copy of a copy was held liable to be set aside. Documents which are merely copies of a copies, the originals not having been satisfactorily accounted for, inadmissible in evidence and must be rejected. In a case of Muhammad Suleiman versus Hariram, 21 Lahore 363, it was held that an abstract translation or a complete translation of a document is not a copy made from and compared with the original within the meaning of this clause. In Monoranjan Paul versus Narendra Kumar Paul, AIR 1994, Guwahati, page 64, it was held that a true copy of the document incorporating a fact of amicable partition supplied from the office of the sub-registrar bearing his seal and signature can be relied upon for its content.